Good afternoon, everyone. This is Candace Bach with the Association of Washington Cities. Thank you very much for joining our Marijuana Systems Update webinar. We're very pleased today to have representatives from the Liquor and Cannabis Board here to provide cities with an update on rulemaking, the new licensing process that will fold in medical dispensaries into the system, as well as some of the enforcement activities that have been going on. I'd like to introduce Rick Garza, the Director of the Liquor and Cannabis Board, Becky Smith, Licensing Division Director, and Nicola Reed, the Marijuana Licensing Supervisor. They will be walking you through a presentation today. We will have the ability to answer questions. To ask a question, you will use the Q&A little question mark up in the right-hand corner of your screen. Click on that. You'll be able to type in your question. Right now, we plan to take most questions at the end. If there's something really pertinent to the conversation, we may go ahead and address it during the presentation, but otherwise, we'll generally save those questions for the end. We are recording this webinar and we'll post it on our AWC website once it's up and ready to go. And again, thank you very much for joining us today. And with that, I'm going to turn it over to Rick Garza, Director of the Liquor and Cannabis Board. Thanks for joining us.
Thanks, Candace, and good afternoon to everybody that's in. We've got a lot of information to share with you today, so I'm just going to go ahead and jump right into it. So first, we're going to share the timeline. As you know, Senate Bill 5052 was legislation that was passed this year that reconciles medical marijuana with the I-502 initiative. So we'll share with you what that looks like. I think specifically we're going to have Becky share with you the investigation and application process. We'll share some information about the emergency rules and the draft permanent rules that will be going out for hearings beginning as early as tomorrow evening. And then I wanted to provide some information about enforcement, what's going on with respect to our producer, processors, and retail licensees, and what does compliance look like. And then, of course, we're going to kind of fly through these if we can so that we have more than enough time for you to ask questions of us. So as you know, the governor signed Senate Bill 5052 at the end of session, April 24th. On September 23rd, we began the process of adopting permanent rules and implementing emergency rules for the marijuana-related legislation. So not only 5052, but House Bill 2136 was also approved and made some changes to our current marijuana laws and rules. It has to do with the ability, for example, of a local jurisdiction to be able to go down from 1,000 feet. But we'll talk more about that in a minute. On October 12th, we actually began accepting retail applications. Like I said, we'll begin public hearings tomorrow, but we'll have public hearings, and I'll show you what that calendar looks like in a second. And then if there are not delays in the rulemaking process, permanent rules, they'll go into effect on January 2nd. And then one thing to keep your eye on in the law that did pass is that if you're not licensed with the state by July 1st of 2016, many of these dispensaries or storefronts that are out there today with respect to medical will become illegal. And then, of course, those who have retail outlets with the state today, licenses, have the ability to get a medical marijuana endorsement, which would then allow you to be able to provide or sell to medical patients if they meet the requirements of the Department of Health. If you're aware of that, they've been having some public hearings on their part of implementing this new law. One of the interesting things that we've seen almost immediately when the rules went into effect is many of those who hold retail licenses today have an interest in also holding a medical marijuana endorsement. So I'm going to hand it over to Becky, our licensing director, so she can cover the licensing process with you.
So good afternoon. This is Becky Smith again. I'm going to just briefly touch on our emergency rules. And what we tried to do here was to really think about what directly affected the local authorities and what you'd want to know more about. So the first thing is that emergency rules went into effect on October, I want to say, oh boy, now I'm going to forget when they went into effect. September 23rd. And why we needed those emergency rules to go into effect is so we could start to begin to process applications for retailers. That, of course, the emergency rules removed the lottery process, so we didn't have to continue to go through those applicants who had put in for a retail store back in 2013. It temporarily removed the canopy. So the plant canopy, as all of you probably know, there was 8.5 million square feet of plant canopy that was approved by the board. And we took that cap off, and now there's no longer a cap at this time. That temporarily removed the retail cap. So where we had said that we would license up to 334 stores, right now there's not a cap on the number of retail stores that we're going to license at this time. That it requires public posting of applications on site. So just like we do with liquor applications, we'll be doing the same with marijuana applications, that they'll be required to post a notice letting the public know that there's a retailer or producer processor getting licensed in their area. It established a priority-based retail selection. So with Senate Bill 5052, if you read that bill, what you'll find is that there's 3 priorities: Priority 1, Priority 2, and Priority 3. It also asks that we establish a merit-based application process. And we currently have a merit-based application process already in place that we're going to continue to utilize. It also allows local authorities and local government to have the ability to lower buffer zones to 100 feet, with the exception, of course, of schools and playgrounds. And then
let me just throw something out there, because I don't know that we're covering it in the next slides, but it's an obvious question when you look at board. Why did you remove the canopy cap? Why did you remove the retail cap? So share with you that in order for us to open the process up, and Becky talked about it a little bit, we had to make sure that we have the restrictions removed, because then we wouldn't be able to issue more retail licenses. So why did we do it at this time? So one of the things that we're waiting for, we're using the same consultant, biotech, that we used Dr. Mark Kleiman to determine what the canopy should be, how many retail locations should we have. So we're waiting for some information to come back from our consultant as to a couple of questions that are really important to determine what the canopy should be and what the retail cap should be. So it's our intention, it's important that you know this, that we will set a canopy cap and we will set a retail cap as soon as possible. So if we can get information back in the next couple of weeks, we can go with the board, because what we need to know is how big is this medical marketplace that's now being merged into the current recreational marketplace. And once we know that, then we'll know how big the canopy needs to be and how many retail licenses we'll need to issue in addition to the, remember there was, the number was 334 retail locations statewide. Right now we're just over 200. It may grow a little more from that, from the original number, but probably not. So I think the idea here in the next 2 weeks to a month at the most is determine how many more by city, how many more we need in order to meet what we believe is the medical marketplace out there. And so I guess I wanted to start with that, to share with you that the board has every intention of restricting the number of retail outlets. And then Becky's going to share with you also what we've learned of those that have applied as far as how many of them will meet the Priority 1 or Priority 2, and that's part of the merit system that was written into the law. But I just kind of wanted to cover that now. I suspect you're going to have questions about that when we go to Q&A, but I just want people to know, because there's been real questions about the fact that if people are already applying, then you'll have to provide a license to everyone that applies. No, that's not our intention.
So let me just go on a little bit more about the emergency rules and the draft rules. And our draft rules are also out for, for for the public to take a look at and to give some recommendations back to us as well. You'll see a lot of what's in the emergency rules and also in the draft permanent rules. And so I'm going to walk through the application process. This is what I just kind of a list of the things that we're going to go over, and to talk a little bit about the application and the opportunity that came about on October 12th. And what we look at for a retail license is a retail license. We no longer look at marijuana as being a medical store or a retail store. That will certainly be determined by the applicant or by the licensee, but they will have the opportunity to be a retailer now for recreational marijuana, and then on July 1st, they'll be able to have applied and received an endorsement for medical and be able to sell for medical as well. We did a priority, we'll talk a little bit about priority assignment, address, confirming the address, what we use for to map our addresses and what to make sure that they're within 1,000 feet of the restricted entity. A little bit about, we'll touch on the initial phone calls and the interview and all the documents that were required, and then the traceability test and the final inspection. We wanted to make sure that we included all of this so you could see what the process looks like for an applicant that they have to go through in order to be licensed as a retailer or a producer-processor. So the application opportunity. So the application process opened on October 12th. To date, I think it's important to know that we've received around 700 applications. That certainly doesn't seem like I think that to some folks it might seem like a lot of applications. For us, it certainly doesn't. That the first time we opened up for recreational retail, we received over 2,100 applications in a month's time. And so 700 seems like a good pool of applications, and certainly not all of those. We've assigned a majority of them, about 600, a little over 600, for our managers to review and prioritize. So what does that look like? You know, that most of you are aware that it goes through the business licensing services to receive an application. It says here it's $250, but it's actually, with the new fee, it's $266, and that's a non-refundable application fee. That, of course, for the medical endorsement, it's a free endorsement. So if a retailer wants to apply to both be a recreational and a medical retailer, they don't have to pay anything extra for that medical endorsement. Right now, BLS is processing and sending over the applications. They're about 5 days behind. So we know somewhere out there there's probably 100 more applications sitting, waiting to be sent over to the board. Again, applications go through a screening, priority 1, priority 2, and priority 3. And then for priority 1, so applied for a state liquor license with the Cannabis Board for marijuana retailer prior to July 1st, 2014. So those are all those folks that, when I talked about the 2,100 applications we received, they would have had to apply for a retail application. Operated and were employed by a collective garden before January 1st of 2013. And so for a lot of licensees or a lot of applicants, what they're asking is that how would you, how are you going to tell whether I was employed by a collective? It's just like everyone else. We're expecting that they give us a pay stubs showing that they were receiving payment. We're not going to allow them to show us a list of marijuana that they received, and believe me, we've received all types of affidavits showing us that they worked at a collective. We're also expecting that these folks pay their taxes. So they would have been paying their taxes since 2013, and they were a state licensed business. So again, for priority 1, they have to have applied for a license for retail. For recreation, they had to have been a collective garden before January 1st of 2013. They would have had to pay their taxes they had to have a business license. All of these things that we're working with other agencies to receive that information. So, for instance, the Department of Revenue is providing us with a tax status showing that they've paid their taxes and they're good on their taxes. We'll also be doing another check later on during an investigation. So it's not going to be this one-time check and that's it. Pay stubs, that's something that they can get from, again, L&I, that we're not just going to accept something that's written or some type of affidavit. And then the Secretary of State, they could show us that they were operating a business license. And then that gets into priority one. If it gives you any kind of an idea of how many priority ones we have, we currently have prioritized 12 people in priority one.
Out of 600?
Out of 600 and almost 700 folks.
That's for growers.
This is just for retail. Just for retail. And then for priority two, it's all of the items listed above, except for they didn't have to apply for a retail license. And what we're finding is that there's not a whole lot of priority twos if they couldn't meet the process for priority one. A lot of folks are behind in their taxes. There's a lot of work going in getting good on their taxes right now, and those are state taxes. So we're talking about B&O taxes right now. And then for priority three, it's anybody who wants to apply can be put into priority three. And so a little bit about when we will start issuing a license. So if
before you go, Sharon, there's a clarifying question. If I could just ask you to address that. Are these priority bullets additive? Do you have to meet all bullets to be priority one, or just one of them?
You have to meet all bullets to be priority one.
Thank you. Thanks for
probably why we only have 12 priority ones right now. So let's go on to the next slide. So address confirmation. So once somebody is put into priority one, and we will be going through stages of when we send these applications to an investigator. So right now, just priority ones are sent to an investigator to begin processing. That I don't foresee priority two coming in until sometime in December, and maybe priority three in January, because we do have that lag time of when people are supposed to get us their information back to LCD. So address confirmation. So once they're assigned to an investigator, we'll ask them to provide us with a good address. And because what we find, of course, and I'm sure that all of you are aware of this as well, is that when an address that somebody applies with may not be the address that they're actually going to do business at, that they'll move for different reasons. Some because of the landlord, and others because they didn't have the right to real property in the first place in order to submit an application. So the investigator will confirm that that's where the applicant is planning on doing business. So mapping, so our GIS, or Geographic Information System, this is what we use, what the investigators use to look at a licensee or an application. So the place of business is to see if it's within 1,000 feet of a restricted entity. As you can see there with the yellow bubble, that anything that's within that bubble would be within the restriction.
Yeah, anything, so that yellow circle is a 1,000-foot buffer, and so there is a restricted entity in the middle, and it's basically doing a circle around the restricted entity 1,000 feet out.
So this just is a little bit more of this tools that we use. So we don't just use one tool to look at the zoning or from restricted entities. We also use Google Map. We go in and search some of the parcels to see where a parcel begins and ends. Do you want to add anything to that, Nicola?
Yeah, we'll often go to the county assessor page to ensure we're looking at the right property line, and then we'll compare it to Google Maps and our GIS system just to ensure we're not licensing anyone within 1,000 feet of a restricted entity.
So once we've done all of this is when we'll send out a licensing notification to the local authority, notifying them that this business is planning on going into, this licensee or applicant is planning on going into business and within their jurisdiction. So initial interview and telephone contact. So the applicant actually works with one investigator, and the investigator will make contact with them and ask them some questions. We want to know, actually, we want to know everything about them. We want to know everything about who they're doing business with. So true parties of interest, the license type, what are they applying for? In this matter, we're talking about retailers, but if we were talking about a producer, it would be, are you planning on being a producer or a producer processor? We want a description of their location. So what is, where are you planning on locating? We want to make sure it's not a house. We want to make sure that their operation's actually a good, sound operation. And then the right to real property. So do they have the right to lease this property? Do they own the property? What does that look like? And then the estimated cost to open up the business. So how much is it going to cost them? And then where are they getting those funds from?
So let me just add something real quick, because there's two different pieces here. The first that Becky just spoke about is how you have to meet the priority 1, 2, 3 of the merit system that was written into the law. What you're seeing now is the process that we take as a liquor board after they've qualified under the priority 1, 2, or 3. This is the piece that we do, and we did this initially with the original retail applications, but I just want to share the distinction is you've got a merit system that was created into the law, and then now you've got this whole licensure merit system that you go through with us, and that's kind of the piece right now that Becky's speaking to.
So we're actually going to answer this the GIS available in every jurisdiction. Nicole, you want to take that?
So we contracted through Esri, and they built the map for the Liquor and Cannabis Board, but the map is available out there for other entities. I know that there are many county assessor sites that use the same map like ours. The functionality might be a little bit different because they're not buffering for restricted entities, but the measuring ability and the parcel lines are all there too. But in short, the local jurisdictions would not have access to our map directly.
So more required documents. So a letter is sent to all principals within the applying entity that requests the necessary forms. So it's just not the applicant that we send these forms to. That we want to know what their structure looks like. So what is their structure? What does their business look like? We look at the personal criminal history statement, operating plan. This is something that all of you might be interested in receiving, and actually can request a copy of an application at any point. But I would encourage you, once it's completed, through our public disclosure, because it does show you in the operation plan, we're looking at people's experience, we're looking at the training, their security, where they're planning on storing their marijuana, that where all of their cameras are at, that it's a very thorough operation plan that we ask from the applicants. And then, of course, the floor plan. That the floor plan just shows what the layout looks like. Again, the right to real property, financial statements and documents. That we took what the Gambling Commission was doing and actually mirrored our application process like the Gambling Commission. And so we do a really thorough financial investigation of all of the folks that are involved in the business or true parties of interest. So a little bit more about the financial investigation that, of course, they're conducted on all true parties of interest, financiers, any person who exercises control of the business. And for financial investigation, for liquor, for those of you who know anything about liquor, that's 10%. With marijuana, it doesn't matter if you give $5 or $50,000, that we investigate every penny that goes into that business, and that's why it seems to take longer to give or to approve a license, is because of all of the all of the investigations that go on. And again, all true parties of interest and financiers, that we look at a variety of documents. That with bank statements, it's 6 months of bank statements. We look at tax returns. We look at where they, why did they get $1,000, $10,000 dumped into their banking account, and where did that come from, and how? And we want to make sure that those folks that are providing money to these applicants or licensees are from the state of Washington as well. So what we found with doing some of the financial investigations too is that we found people that were actually living in California but had initially met the requirements here for living in the state of Washington, but going back even a few months, we found that their day-to-day business was being conducted in the state of California or Colorado or Utah. So we've, you know, that as you know, bank statements show a lot about what people's spending patterns are like. And then fingerprints. Every true party of interest and financiers are fingerprinted, and their spouses. Again, much different than alcohol or our liquor side, that I would say that not all spouses were happy to know that they had to be fingerprinted through this process. It goes through Washington State Patrol, and then the application, the applicant can actually schedule a time with Philprint to get their fingerprints taken, and there's locations all over the state of Washington, so we're not expecting that they're going into their locals to get their fingerprints run, although I'm sure some have. Document review. This is all of the documents once we receive. The investigator goes through all of the documents to see what's there, what's missing, what we need to have redone again, that before we do any type of a completed investigation, we want to make sure that we've received every piece of paperwork in order to send an application up for final inspection. So once that's, can you just go back one? So once we have received all of the information and that the application appears to be completed, what we'll do is that the supervisor reviews it to make sure that it's complete, and then it goes up to our enforcement. And it goes up to our enforcement consecutively with why we're doing the traceability system. So each applicant is required to take a test within LCB's traceability system, and that's to make sure that they understand how that system works, that they know how to receive product and what it goes into as far as selling it, that every piece of I would say every sale that's done in our retail stores has to be tracked. We can track marijuana from when it begins to grow to when it's sold in a retail store. And so if we needed to pull back and there was something that happened with the product that was out there, that we could do a recall and know what stores were carrying that product as well. Again, they have to receive a 100% score in order to pass the traceability system. So final inspection, what does that look like? For final inspection, again, different than liquor, every single one of our licensees, anybody that's licensed to produce, process, or sell marijuana receives a visit from our enforcement officer. They spend about 2+ hours at at the location. They go over the alarm system, that the video surveillance and recording, they actually have to be working. They have to make sure that their security system is working. They look at what areas are secure. So are there cameras where there's supposed to be cameras? Are there cameras in quarantine areas? Are there cameras outside of the business where we do point of sales? And then it says here that no plant material may be on site during inspection. That's for producer processor. For retailers, there should be absolutely nothing. It should be everything, and actually even for producer processors. When I've gone on inspections with the enforcement officers, what you'll find is a empty yard or empty farm, or you'll go into and you'll go into a business and see that there's nothing on the shelves. There's nothing at all. We see nothing inside of that building. All we're looking at is cameras inside and out, and to make sure that they have everything that's required. And again, enforcement goes through and does a briefing with all of these licensees to make sure that they understand what's required of them, both in the traceability system and what they're supposed to report. And then it goes to fees collection. So once an enforcement officer says they're good to go, they come back down to our investigator, that the supervisor reviews it. I review every single application. So out of the 780 plus producer processors, I've read every single one of their applications before they go on and get licensed. And the same thing with the 210 retailers. I've reviewed all of their applications before I signed off on it in order for them to go to fee collection. And then they become licensed.
So let's just stop there for a moment. So I guess we wanted to share, the initial application process was cumbersome, like a liquor license, but even more so now for cannabis, where the idea of fingerprinting those investors or financiers, their spouses, goes even further than what we do for liquor. For liquor, you go through a criminal background check if you're the applicant, or you have 10% interest or more in the business. Here, it's even more cumbersome. So it's probably not so much of a surprise that, remember, initially we got over 7,000 applications. We've issued 700, a little over 700 producer processor licenses and just over 200 retail licenses. So you're talking about less than 10% that are qualifying even to be in the business. So you think about that process, and then you think about this one that now puts another layer that you have to go through in order to hold a license, that whole priority 1, 2, and 3 system. And I guess what I'd share with you is that makes us believe, just from the experience we had before, that it's going to be hard for people to come through this system. You got to go through the merit-based system and the law, the priorities. Then you've got to go through the system that Becky just shared with you.
And I think to know too is that we had when I'm surprised that there's such a thing, but there is such a thing called weed maps. And so as we're looking at if somebody is a dispensary, that we're finding that there's over 2,000 medical dispensaries out there currently operating and doing business. And that's what we're looking at when we look at whether somebody is operating a medical dispensary. We sometimes go to weed maps to see if they're an actual business or not. And so for us, that there's some of these medical folks that are currently operating are really serving the recreational market and not truly serving the medical market. That one of the things that was important for LCB was to make sure that those patients that were true patients, that we had the ability to have retail stores that have that medical endorsement throughout the state of Washington. So if somebody needed to get their medication that was a true patient, they would be able to have access. And so with having 50% of those retailers already have their medical endorsement, that's good for us. It's good for those patients out there that are going to need to have access to something other than recreational. That for the recreational side, and what you'll see in a rec store that you won't see. Currently, if you walk into a dispensary, I guess what you'll see is that every type of product being sold. If you were out walk into our recreational store, that anything that's on the shelves has been approved. That we have a extra layer that also looks at a four-person panel that actually reviews every single edible that's sitting on the shelves, and that's different than any state. I would say that there's no other state that actually has that panel that reviews product to see if it's appealing to kids. We look at the color of the product. We look at how much the labeling of what before we do label approval, before we allow for that product to hit our shelves. And so know that there is that extra layer. Will medical patients be able to access edibles. I think Department of Health has 4 or 5 types of medication that'll be able to be accessed in our stores. But a retailer is a retailer, and it's their choice to whether or not they're going to actually get a medical endorsement. Nicola, is there anything that you wanted to add?
No, not on that part.
Sorry, Becky, this is Candace. Just a quick clarifying question that popped up. Are the new retail license applications being accepted if they do not intend to obtain the medical marijuana endorsement?
Yes, they are. They are. They are because, again, let's go back to there's quite a few of these dispensaries that are actually serving the recreational market and not truly serving the patient. And so I don't know if that's, I guess what's going to be good after we receive our report back is to know how many that is. I mean, is it 80% of the market should really be recreational and only 25% medical? We'll get a better look at what that is.
Thank you.
Yeah, I think that's a good point. Remember that much of the debate the last couple of years with respect to medical has been that the vast majority of it serve truly recreational users. So the idea here is to open up the system to allow them into the system, and that's why it's not a medical or recreational or a medical/recreational license. It's a retail license. You can choose to be medical, you can choose to be recreational only, or both. I suspect because we've got over 50% of the current licensees that want to get a medical endorsement, that they want to do both. But for instance, if I'm a person that wants to buy medical grade marijuana as defined by the health department, I don't need to get a card. I can go and purchase it if I want. I just won't be able to enjoy the sales tax exemption that you'll get unless you go and qualify as a patient. So you're pretty open to use that system in any way you would want.
And you won't be able to purchase, without that medical card, you won't be able to purchase as much marijuana as, you know, that somebody with a medical card can purchase more marijuana than the recreational user. So it gives them some, you know, some ability to purchase quite a bit versus an ounce.
So remember that the priority system was put in the law because the intent was that, and I'll take Thurston County as an example. Just after the initiative passed, we saw dispensaries sprouting up everywhere in this county. So probably 3 times the number of dispensaries today than there were before I-502. So the intent of creating the priority system, when you look at priority 1 or 2, was to allow for those medical dispensaries that were around when the original law was passed in '98, but not to allow those that have just taken the opportunity to become dispensaries because they knew that they weren't going to be closed down, especially if you were in Western Washington. But the idea of this whole system, this merit system that was put in the law, as I understand it, was to let those, I don't want to say that they're not legitimate, but the dispensaries that were there before the initiative passed into the system first. And what I'm hearing Becky say is when you look at the first 600 applications or more, you've only got a handful right now. They're going to even qualify under priority 1. And so be aware of that, because I know you've been concerned about the timing of this, especially with the local jurisdictions that feel like, well, I need some time to go before my council or before the mayor to get these new rezones, for example, if they're interested. I kind of heard Becky say that we probably won't get beyond the 1 or 2s for at least a month or 2. And again, if you've only got 12 that have qualified to this point, I'm not sure how much concern there would be about that. I think what people are hearing is that, for example, there may have been 200 applications within King County or the city of Seattle. Obviously, we only allowed for 21 in the city of Seattle originally. So in their mind, they're thinking, oh my gosh, does that mean, you know, we're not even a month in and you've got 200 potential retail locations in the city of Seattle? That's not likely to occur, because by the time we get into this very much further, we're going to already set a number for retail locations based upon the information we get from our consultants. So I wanted to throw that out there.
Yeah. And go back to what Rick had just said, is that if you take a look at the city of Seattle and all the dispensaries that are currently operating, there's probably about 200 of them in the city of Seattle, all throughout the city. So just keep that in mind, is that we have no intention of licensing 200 people in the city. Nicole, do you want to take that question about
yeah, sure. So let me go ahead and read that. There's a question that they're going to take. Will RCW 6950-328 prohibiting producers and processors from having any direct or indirect interest in a licensed retailer apply to stores with medical endorsement?
Yes, because essentially they have a recreational retailer license with a medical endorsement, so the rules will still apply, that they can't hold both. So they can hold a retailer, or they could hold a producer and or processor, but not both together.
And the rule actually continues to prohibit them from owning more than 3 retail licenses. And so it doesn't matter if they hold 3 in Seattle, that's all they get is 3 for right now.
Okay, one more clarifying question before we move on. Did you say you're going to be revising the allowable retail numbers for each jurisdiction?
So yes. So we're actually going to, once we get BOTEX, I always want to call them biotech, BOTEX report, we'll take another look at what that report tells us and be providing the number of cities and counties, the number of stores that we'll license.
And I think I heard you say that will happen sometime in maybe the next 2 to 4 weeks.
Yes, so they're required to have the report back to us by the end of November.
So I think, yeah, let's revise that. If it's the end of November, it could be as early as the middle of November, which would be, a couple of weeks. But I think to give us some time, plus we need to go, staff will need to bring a recommendation to the board based upon the information we receive of what that number should look like. So probably it's safe to say it's going to probably be more like December before we set that number.
Don't read it.
Why don't you go ahead and, you wanted to answer that question?
Sure.
Okay, one more question, then we'll hit that last slide. So the question is, how can anyone qualify for a Priority 1 processing license since there were no legal collective gardens due to the Cannabis Action Coalition, Arthur West versus City of Kent case?
So I won't speak just, Nicola, directly to the case itself, but collectives themselves were legal, and we are finding that there are people that obtained their state and local business licenses and permits in names of a collective garden or a consultant. They had came forth that it was a marijuana business, and then the UBI matched their tax status letter. So from the beginning, they've been paying all applicable state taxes for that business. So there are quite a few that will end up in Priority 1. It's just not going to be the majority.
Thanks. So we do have a number of other questions. We'll come back to those at the end.
So just because we've got you and we've got an opportunity to update you, wanted to give you some data and trends with respect to our enforcement. So very similar to liquor, we have 100 liquor enforcement officers statewide. I believe we have 22 officers that we were given originally through I-502 and also additional ones with the passage of this last law. But just so you're aware, like we do with liquor, we have officers go in and do premise checks, and we've done 1,362 with the number of retailers that we have today, which is a much larger number than we have for liquor, I'll tell you that. But then, of course, we have so many more liquor licensees, but that's averaging around 7 visits per retailer. Now, that's different than a compliance check. Remember, a compliance check is where we use a person underage to go in and try to purchase. But I did want to let you know, so you know, out of the 210 retail licensees that we have, and this would also include producers and processors because we're doing premise checks with them. But obviously, when we go into a premise, we're looking to make sure that the security is still in place, that the cameras are working. Sometimes when we're looking at through the traceability system, we're actually tied into one another. We have examiners and auditors at the board that look at the traceability of the system to look for any kind of anomalies with respect to what they're reporting. And then we'll go in and do a premise check and make sure that it fits with what they're reporting. So I just wanted to share with you that's going on a daily basis. And then, as you probably heard, we began doing compliance checks with minors back in May. Interesting enough, the compliance rate looked very similar to what we see for alcohol, a little lower. And typically, you know, we went 10 months before we did any compliance checks. And typically, you're going to have a lower rate. The more you do of them, the higher the rate's going to be, just like with anything. So we're hoping that we'll do better in the second and third round of compliance checks. But just wanted you to know that we've done compliance checks. So you look at 271 compliance checks, yet you only have 210. Well, those that sold, again, it was 12%. We go back a couple of times more and continue to do compliance checks to make sure that they are compliant. And so we do that for liquor. If you get a violation for selling to a minor, we'll be back within 3 to 6 months to do another compliance check to make sure. So that's why you see more compliance checks than the number of retail licenses. So, and then we give you some kind of the top 3. What are the issues that you see with respect to violations that have nothing to do with compliance checks or minors? We also have folks who violate the advertising restrictions that are pretty strict within the initiative, and then we find violations like, oh, you didn't tell us that this person actually, or persons, had an interest in the license, and so they need to be placed on the license, and we actually write a violation for that. And then obviously if there's a failure to utilize or maintain the traceability system, people sometimes will not be reporting what they're supposed to be reporting when changes occur. They move product from one place to another. They sell product to a processor or to a retailer. If we see that they're not putting it in the traceability system, then we issue violations for that. So obviously, some folks are late or they're not reporting their taxes, and so they get violations for that. The traceability system, like I just said, and then we've written up 32 violations for sales to a minor.
And Rick, this is Candace. Could you tell us about some of the penalties for these kind of violations? Have you had to do any license revocation or license suspension as a result of any of this?
I don't think we have yet, but so when the original penalties were put into the law, we actually used a standard penalty guideline like we do for liquor. We actually doubled the monetary penalty and doubled the suspension days, so it's probably twice as tough as it is for alcohol. We have the ability to do that by rule because it basically in the initiative gave the board the authority to set up what those penalties should be. And those are administrative penalties. Criminal citations can be written, and it's a felony right now, for any adult who sells to a minor. So there's 2 different flows with respect to violations. But what I'm talking about right now is administrative violation that gives the board the ability, ultimately, if there's too many violations, to remove or cancel the license. That's different than local law enforcement coming in and writing criminal citations for a person selling to a minor, for example. Because like for liquor, as you all know, you have to be 21 in order to possess or purchase. So that kind of gives you a snapshot of where we're at.
And for licensing, we've actually have revoked a producer processor license already, and that was for failure to disclose. So we do go back, and if we find that an applicant that's now licensed was dishonest or lied on their application, then we do have the ability to go back and, you know, depending on how severe it was, to go back and revoke their license. And for that individual, it was severe enough that we revoked their license.
So a question on violations. Are the violations of compliance checks being reported to the local jurisdiction or prosecutors?
They are.
They are.
So we'll provide especially for selling to a minor, we'll send that to the county prosecutor, and they get to determine, he or she, they'll get the file. We don't do anything with it other than to hand it over to the prosecutor who can determine whether they want to take criminal action against the person. We deal, you know, just with the licensee and their license. We don't get involved in the rest of it. But what we've seen is a reluctance by prosecutors to take it any further because the courts are looking at it going, really, you want me to take action against this particular adult who sold to a minor? I mean, it's something we struggle with alcohol, for instance, because they already know we can cite them administratively. We can take the license away from the licensee. So you're compounding it by now taking criminal penalties or taking a felony to an adult, but you have the ability to do that if the locals want to do that.
Great, thanks. So we had a number of questions that came in. I'm going to go back through those, and Rick and Becky and Nicola, you guys can see who wants to answer them. So I think one of the first questions that was asked was, will a city be able to allow medical marijuana retailers but not recreational retailers?
Yeah. So we'll be licensing retailers. We won't, there won't be a difference for us. There will be a retailer with a medical endorsement. So they won't, completely up to the licensee whether they want to sell medical or sell only medical, but it will show for the local authorities that we're licensing for retail.
So from the state perspective, there's no difference.
No.
So if a local jurisdiction decides they want to take that action, that's going to be their own legal counsel who will have to determine if that's possible.
I think you've got local jurisdictions today who have banned recreational and not medical. So the question, made me think about the fact that they've done that, but that's not something that we would enforce. To Becky's point, if you want to say only medical, I guess they could call us and ask us if they're medical only, but that's not what we're licensing.
Yeah, we're not licensing for medical only. We're licensing for retail.
All right, one of the next questions that was asked was, I think you kind of addressed that, but we'll just make sure. Will the retail cap include a per city or per county cap? Will you go down to the city and county level again with those caps?
Yeah, so we are planning on going down to the city, as far down as the city for the cap.
Has the board considered requiring written notice of applications for growing and processing applicants to be given to property owners within perhaps a certain distance of the proposed location? Some kind of maybe public notice or written posting or something that would go to all of the property owners within a certain radii of.
Well, now with new applications or change of location, the actual premise will be posted with a public posting notice for 14 days. So that would be the notice for the local businesses around that area. And then also the local authority notice that goes to the LA, and they have 20 days to respond.
But certainly a local authority could decide that something within their jurisdiction would be to require an applicant to send notice to everybody within. I mean, that's up to a local authority to do.
In terms of determining the priority status, is the Liquor Control Board only concerned about, about B&O tax or about retail sales tax that the Department of Revenue believes are due on the sale of marijuana?
So it's not just on the sale of marijuana. So we're expecting that they've paid their B&O taxes for whatever business they've been involved in. So right now, that for prioritizing, the Department of Revenue doesn't go as deeply as they do for our retailers once we license them, and they certainly will, but not to get them into the priority. Because of the time frame, they don't have the ability to go that far down. But before we license them, we'll be looking at other taxes as well. And we also look at their child support statuses. So it's not just, it's whether or not they're good on, have they paid their L&I taxes, have they paid. So we're looking at not just their tax on marijuana.
Okay. So kind of a full scope of everything that's due. Let's see, I think the next one is we answered the first couple. Let's see, so the next question is, in what tier does an existing retail facility fall if they want to obtain a medical endorsement?
So if somebody's currently a retailer, they can obtain a medical endorsement. It's just a request that they make. It's an application process through LCB. We actually don't put them through priorities because they're already licensed.
Can you explain the changes to the advertising rules?
So can you be more specific?
I guess, are there changes to the advertising rules that came out of 5052? And if so, what are some of maybe the more significant changes?
You're allowed 2 signs now, so that would be one of the more significant ones.
That's the only really significant one that I can think of.
So loosened a little bit with the 2 signs, but not more significant.
Yeah, we receive a lot of complaints about advertising, and so that that advertising over the internet, advertising with and I'm sure folks have seen the big billboards, and retailers are allowed to have the billboard as long as they're not the owner of the billboard. That it can even be sitting on their property as long as they're not the owner of the billboard.
Yeah, so remember that the original law created a 1,000-foot restriction for advertising from the same entities that you can't hold a license and be close to: schools, playgrounds, parks, libraries, arcades. The idea was to keep them away from where kids would be present. Those advertising restrictions apply to any advertising, whether it's the licensee or someone else. Those stay on the books. But to Becky's point, the only restriction that I have as a licensee before the change that was just made is that I could have a 1,300 square foot sign that advertised my business on my premises. That's as big as it could get. But if I wanted to advertise like next door, because I don't have any control over that, it's not part of my licensed premise, then I could have a large sign there as long as it doesn't butt against the 1,000-foot restriction for those entities. And that's what we're seeing. So people are upset and they're saying there's a billboard, or the billboard's right next to the licensed premise. Well, I don't have any control over that billboard other than maybe I paid for the advertising, but that's not part of my licensed premises. So it kind of gets back to, for a lot of people, I think they have concerns when they see the advertising, but remember, it's a legal product today. So their First Amendment issues with respect to restrictions in advertising, unless you can tie it to youth access or kids, which is really what was done in the original initiative. And so we do get involved in advertising that may be appealing to children. Though we have pretty strict rules with respect to that, but not when it comes to adults. It's really going to be difficult for us to create those restrictions above what the law already has in place.
The next question we got up there is, can local police conduct marijuana compliance checks using local investigative aids like they currently do with alcohol?
I don't know why they couldn't. I think they have the authority to do that, but I think before I say they can or they can't, I'd almost like to go back to enforcement. I know that we're not doing that right now, or they're not doing that right now. It's really us, Candace, our liquor enforcement officers, that are doing the compliance checks. I don't even know that the locals, there may be instances where the locals or local law enforcement is with us just to see how the compliance checks are conducted. For why we wouldn't want that in the future, we would, just as we do it for liquor today. So I can tell you we'd want to be able to do that. If we have more people out there doing compliance checks like they do here in Olympia, local law enforcement goes out and does, sometimes on their own or in conjunction with the liquor board. We want that. So whether, I just don't know that we're doing it, and I don't know if there's any issues with respect to local law enforcement doing it. I don't think so.
So a local law enforcement agency that wants to should probably check with their own legal advisor and maybe give you a call.
And give us a call, yeah.
Let's see, next question. Does the Liquor and Cannabis Board consider local zoning before granting licenses?
So we actually, that local zoning or moratoriums or bans are a local issue. It's not a reason that we can deny a license. It's certainly, what we tell licensees and applicants is that, they have to, we can license them, but they ultimately have to follow the rules of their local jurisdiction. So it isn't we consider it, but we can't deny a license because of it.
So remember, in the original Attorney General opinion that we went out seeking was kind of conflicting information that came back to us, and it seemed to suggest that we didn't have the ability to enforce local zoning, and at the same time, you know, the opposite, which is you can't issue the licenses board because there's nothing in the law or the rules that speak to the fact that locals have the ability to ban. But at the same time, if you remember the opinion, they said locals, because the initiative was signed, have the ability to impose their own bans.
Yeah, I think we've covered this a number of times, in that a local jurisdiction can enforce their own zoning regulations, and the state will enforce the state's regulations. Let's see, the next question I think maybe is more of a statement, but that local jurisdictions may have advertising restrictions in general, and I think that's certainly the case, as we just talked about with local zoning regulations. It's the same with local fine codes. A local jurisdiction can have their own fine code regulations and enforce those independent of the Liquor and Cannabis Board's regulations. Next question, again on signage, it looks like there seems to be a proliferation of sandwich board signs placed on the sidewalk or in the parking lots near retail outlets. Are those legal?
They are legal. Yeah, they are legal. So it depends on where they're at, right? So if they're on property that's city property, they can put them out there. But if it's a sign, they can only have, well, they can have up to 2 signs now. At the time when we started, they could only have 1 sign, and that was a sign over their business. But if they had a sandwich sign, they put it on city property, they could have that sign as well.
But again, if a local sign code has restrictions, then they should be being compliant with local.
The sidewalks are public property, so the city or the county could take action there immediately to remove those sandwich boards for whatever business, right? But the only thing we can do is address that which happens on the premises.
So the last question, it looks like, unless somebody's typing furiously at their computer, are LCB investigators performing mapping checks for potential buffer restrictions before sending notice of application to local jurisdictions, or is the local jurisdiction notified first?
This is Nicolette. So the mapping is completed prior to our telephone interview with the applicant, and the local authority notice is sent out after the interview. So we do the mapping first prior to sending the notice out. That's not to say that something could have been overlooked, and maybe the public will let us know that there is, in fact, something there after the fact. But for the most part, all the mapping is completed prior to.
Our GIS system is only as good as the information that's inputted into it, and runs about 3 months behind. So there are times that something pops up that we're not aware of, that a city or, well, it's usually somebody from the community that lets us know that there is a restricted entity within 1,000 feet of a licensee.
So follow-up question to that. How would a city find out if the LCB's mapping matches the city's map? Probably just need to call you and check.
Yeah, this is Nicola. They would just need to give us a call. The maps would be very different because the map we're looking at would be specifically looking for restricted entities. I'm not sure if the city maps would be doing that. So I would need more clarification if they're talking about parcel lines specifically or actual restricted entities.
So it sounds like you, though, in terms of the GIS mapping product that you use, is pulling data from a lot of the same sources maybe a city's mapping system is pulling data from. So it's probably just a question of if the city has concerns, they should call and check in with you and see if you've got the same kind of data that you're looking at. Another question, this is back to signage. Is the LCB considering how to regulate marijuana signs in light of the recent U.S. Supreme Court case of Reed versus Town of Gilbert, which essentially held that content-based sign regulations are presumptively unconstitutional? And first off, I'm not sure that we don't have an attorney in the room, so maybe we need to defer this question, but my understanding of the Reed case, and there's a bunch of attorneys on this call, is that that was for non-commercial based content, and it didn't truly address commercial based content, although certainly it calls into question where the Supreme Court could go with commercial-based content. So anybody from LCB up to speed, feel confident talking about READ? And I'm getting head shakes. So I think that's one that the city attorney community is probably going to have to put their head together and talk about how and if READ.
Yeah, I'll be honest with you, I wasn't even familiar with it. So we're not considering anything. I mean, looking at the question, we're not considering anything, but I think we'd have to get back to our AAGs to see whether that's something that matters to us or not.
Next question, is there still a prohibition against using the marijuana leaf as part of a sign or to advertise a business?
So it depends, and I say it depends because sometimes we have the marijuana green guy standing out there as advertising. But as part of a sign that, that we'd ask that they don't use big marijuana leaf on their sign, or that they're not going in and making promises that this is that this is going to cure cancer, or or that it is what was I going to say? Therapeutic. And so anything that's in their business that as far as their name, we're asking that they remove that. In the very beginning, there are folks that we've missed the leaf, we missed the therapeutic piece, and on renewal, we'd probably go back and ask that they make those corrections.
Thank you. Next question up there, let's see, is will the LCB shut down medical providers after July 1st, 2016 if they remain unlicensed? And this is the question I think Rick and I were discussing prior to the webinar, and who will be taking that enforcement action against those that do not have a state license after July 1st, 2016?
It's like it is today. We would look to the local jurisdictions, we'd work with them. I think given the resources that we have, our responsibility is to make sure that the licenses that we currently provide for producer, processor, and retailer are compliant. That's really all the resources we have to go out and begin to take action to close down dispensaries. It's just like if we find a steal today, to be honest with you, on the liquor side, we go to law enforcement locally and work with them, whether that's a sheriff's office, whether that's local law enforcement, and say, we need your help to take this down, and then we confiscate the alcohol. But I think all the work that we've been doing so far has been to work and provide questions and provide answers to local jurisdictions and prosecutors and others that I really think that responsibility is yours. They've been reluctant to do it because there hasn't been a law that said that these dispensaries, these storefronts are illegal. They could have taken action because many of them are illegal as far as how they're conducting their business. The 98 law allows you to grow a number of plants for yourself or other providers, but as you know, some of these storefronts are providing product to thousands of people, which was not the intent of the original law. But I think for the board, given the resources that we have, just like we do with liquor, we would look to local jurisdictions to help us with that.
So a related question is, will collective gardens go away? And I think we've talked about this, yes, in terms of Senate Bill 5052, basically eliminates collective gardens effective July 1, 2016, and replaces them with this state license system, as well as cooperative grows, which are up to four-person cooperatives for patients and their designated providers. So I think the answer is yes, but Rick or Becky, do you want to expand upon that at all?
Yeah, this is Nicola. Like you said, so July 1st, 2016, collective gardens become illegal. Senate Bill 5052 did think about the patients out there and are allowing for cooperatives. They would have to register with the Liquor Cannabis Board, geez, I'm losing my mind. And they're allowed up to 4 people, and there would be a max of 60 plants, depending on how many of them are issued, how many plants per person. They would have to grow at the domicile of one of the participants. If someone leaves, they would have to wait 2 months before replacing another patient. So there's just some stricter guidelines regarding it.
And then remember, there's also a provision in the law that allows you to grow for yourself. So you don't have to. I think there's some concern from patients that there may not be locations where they can pick up product that they can pick up today. So I think that's why the law provides them to form cooperatives for more than one or grow your own. If that works for you.
So a follow-up question, I think you've answered it at least in part, is who will be enforcing cooperatives in the future, i.e. cooperatives that are within 1,000 feet of a retail facility, and whether they are registered or not?
Well, if they're registered, it would be the liquor board. If they're not registered, we fall back on what I said earlier.
So local law enforcement for those that aren't registered. This one goes back to, I think it's a follow-up on the posting question. Since the Liquor and Cannabis Board's license issuance is the crucial activity for this type of activity, and counties will view it only as a zoning issue, is there a reason that nothing more than just a posting of notice on the property is the only notice given? I think this is going back to why not require a broad, perhaps mail posting.
Yeah, it was what was required under Senate Bill 5052. It wasn't that we went back to what liquor currently does, and again, there's no reason that the local jurisdiction couldn't require more of an applicant, but for now, that's that's what we would require, is just a posting notice.
But to your point, the locals, through their own by ordinance, could require that anyone within 1,000 feet or whatever distance from a notification that you get from a civil licensee could require that they be notified. They could be notified by the local jurisdiction, for example, because you would know. But that would be difficult for us. I mean, we wouldn't do that. We don't do that for liquor today.
I think, I was almost too late. I think we'll make this our last question for this for the webinar. Are medical marijuana delivery businesses legal today? Will medical marijuana delivery businesses be illegal after July 1, 2016?
So they're actually not legal today. That certainly, again, it's up to the local jurisdiction to take that on, but they're certainly not legal today. And I don't know that moving forward, I mean, I think that that's a decision that we'll have to take a look at.
I think in the more remote, rural areas of the state where bans and moratoria exist, we may want to look at whether we need to provide on a limited basis, with exception, the opportunity for patients to have it delivered. But what we're hearing is going on in Seattle with respect to delivery has nothing to do with the fact that it's too far a distance to go that I need to have it delivered to me. That just has to do with people making commercial business out of the fact that they're delivering marijuana all over the city, if not the county. So, I mean, we don't want that to occur in this, but there may be instances where we need to look in the more rural areas to make sure that patients have the ability to get the product.
I mean, certainly we just started allowing for the delivery of alcohol. That hasn't been, that hasn't been in effect for very long. So just consider that number of years that we've been regulating liquor.
Okay, so this, I promise, really is the last question, and then we'll wrap it up. Does the restriction on using marijuana in public also apply to homegrown and cooperatives where the product is visible from neighboring property or a public right-of-way?
Well, you've answered the question in the question almost, because you said the restrictions of using marijuana would have nothing to do with growing it, right? I mean, you can grow it and not be using it. But the issue of public consumption or smoking in public or consuming in public is still on the books. Now, the difficulty is if you're in your front yard and you're consuming, that is your private place. So no one, I think, is going to probably go after that. But I think that's a difficult one, especially when people are living in apartments and whatever, of people consuming in public. If they're consuming in their apartment. Is that public? But typically not. So anyway, but to the question, I don't think, I think they're two separate questions.
I can speak to the second
Sure.
part. This is Nicola. As for home grows, we wouldn't have any authority whether they had it hidden from a neighbor, depending on the fence line or whatever it might be. But when a cooperative registers with us, they will have to submit a site plan and show us where the marijuana will be growing. And if it's outside, we're proposing that they would have to meet the 8-foot height requirement for site obscure fencing.
Which is what we require now.
Yes.
And some jurisdictions actually require something higher than that as well. I know on east of the mountains they do require that it's, yeah, I want to say it's 10 feet in some jurisdictions.
Well, first off, I want to thank Rick, Becky, and Nicola for participating today. We've had a really good partnership with the Liquor and Cannabis Board when it comes to education, and you've always been really great and willing to participate in our conference forums and these kind of training opportunities. So thank you again for participating today. For our audience, we have been recording today's presentation. We will make that recording and the PowerPoint available afterwards on our website. We have a number of resources on the AWC website, including a summary of Senate Bill 5052, House Bill 2136, and information about the marijuana revenue sharing distribution. So if you're interested in more information, you can check out our AWC website. I also want to put in a plug for the Liquor and Cannabis Board's website. They have a tremendous amount of information and resources on their website, including their marijuana dashboard that gives you kind of up-to-date information on the number of licensees and everything that's going on with the industry right now. So it's a very useful website, lots of good information. So please visit that as a resource. So I think with that, we are going to end our webinar. Again, a big thanks to the Liquor and Cannabis Board, Rick, Becky, and Nicola for joining us today. And thanks to all of you for participating in this webinar. And we will call it a day for this. Thank you.
Thank you.